Ladies and gentlemen, welcome to today's show, 11 o'clock hour here on Talk Radio 1190. This is Ask the Experts, and I'm the host of the show. We interview local prominent professionals here in the Dallas-Fort Worth on what? Well, their area of expertise, of course. Joining me on today's show, it's great to have him back. It's personal injury attorney Mark Underwood. Before we get to Mr. Underwood, you can find him online at underwoodlawoffice.com. It's underwoodlawoffice.com. The phone number to reach out to the fine folks over there, well, it's 844-UNDERWOOD. That's 844-UNDERWOOD, and his office is located in McKinney, Texas. Mark, it's great to have you back on the show. How you doing today?
I'm doing great, Matt, except for the hot weather that we've had for the last 2 weeks. About to drive all of us crazy, I think.
It's been insane, right? I mean, we're used to hot weather here in North Texas, but I think it's safe to say it's been especially a little bit hotter summer this time around, right?
110 degrees one day, 108 degrees the next, 106, 109. You pick it, anywhere between 105 and 110 is what we've had to suffer through.
Yeah, our idea of relief around here is 95, 96 degrees, and that's still really hot.
Yeah, I pray for 95 degrees.
Yeah. Well, I'll tell you what, we got a busy show today and a lot of information to cover. Of course, we have you on. You've been with us for a long time, but if anybody's ever missed a show, I always like to kick it over to you real quick before we really dive into things. Tell them a little bit about yourself.
Hey, so I'm a lawyer in McKinney, Texas. We handle the worst disasters in the entire country, everything from major industrial disasters and explosions all the way to medical negligence case. If your life has suffered through a disaster, like we say, when disaster strikes, give us a call. 844-UNDERWOOD.
Yeah, and like I mentioned, he's a personal injury attorney here in the Dallas-Fort Worth area. Today we're going to focus on, he kind of implied it, injuries that you suffered in the result of medical negligence. And we'll just jump right into it. Mark, what are some of the most common types of medical malpractice cases that you tend to see?
So, hey, you see a lot of failure to diagnose. You see some birth injuries. You see some anesthesia injuries, and sometimes you see some medication errors. I wanted to tell the people in the audience about 3 of the medical negligence cases I've handled over the years that are pretty fascinating. The first one, which was featured on the Oprah show, was a gentleman who is a locksmith that went in to get carpal tunnel syndrome, and surgery on carpal tunnel syndrome performed. And about a week or 2 after the surgery, he went back to the doctor and said, "Doctor, I got a different kind of pain in my hand now." And the doctor said, "Well, let's schedule you to come back in 30 days. It's going to take some time for it to heal up." So 30 days later, he goes back to the doctor, complains of pain in his hand where the surgery was still. Doctor says, "Well, it's just going to take some time. We'll schedule you in 6 months." 6 months goes back. Pain's gotten a little less, but still has pain in his hand where the surgery was done. And the doctor says, "Well, you're basically going to have to live with it." Well, 10 years later, he's in a car. The client was in a car crash and had a lot of pain in his hand, gets an X-ray, and they find a surgical blade that had been left in his hand, had been there for 10 years causing him pain. He had just learned to live with it.
Unreal.
So that was a pretty interesting case. Ultimately, they decided that too many years had passed and the statute of limitations had expired, so he was out of luck. Another case that we recently did here in Texas was a woman that had a shunt running from her brain to her stomach to drain fluid off of her brain, and she went in for bariatric surgery. And while she was in there for bariatric surgery, the doctor cut her shunt in half and didn't repair it and didn't talk to a neurologist about repairing it. Sewed her up after the bariatric surgery. Client went home. Over the course of 2 months, she was feeling tremendous amount of dizziness. Went to a neurologist. They determined that the shunt had actually been cut and was no longer draining into her stomach. and we were able to get a successful recovery for her. Another case we handled a few years back was a gentleman who had tried to kill himself and was taken to the hospital. He was transferred to a larger psychiatric hospital, and he was kept there for a couple of weeks. And when his insurance ran out, they decided to discharge him. And the doctors called the family and said, "We're going to discharge him tonight at 9 p.m. You need to have somebody here to pick him up." And the family said, "If you discharge him tonight, he will kill himself." And the doctors actually wrote that in the chart, that the family had told him that. Well, sure enough, they still discharged him. And by about 2 o'clock the next day, roughly 12, 14 hours later, the gentleman had killed himself. So there's kind of some fascinating twists and turns on medical negligence cases. Some of them aren't quite that interesting, but there's a lot of different types of medical negligence. But they're some of the most difficult cases in the entire legal system to handle.
Yeah, and I think we've talked to, maybe me and you personally have talked about the wrist one, and I thought that was astonishing, and I think people are surprised that this actually happens, but it is a thing, and it can happen to you, surprisingly. Now, and hopefully that's not the case, but in regards to standard of care, let's touch base on that. What does that really imply?
So you have to prove in a medical negligence case that the standard of care was violated. So before you can prove that it was violated, you have to prove what the standard of care is, right? And essentially the standard of care is how a similarly qualified medical professional would have handled the patient's care under same or similar circumstances. So, for example, in the shunt case where the shunt was cut, we had to prove that other doctors would have done the bariatric surgery without cutting the shunt that was in place. So it's how the medical professional, physician, doctor should have performed under same or similar circumstances.
Now, if this does arise and if somebody's in this situation, if they're a patient, who can a patient hold liable if there is medical malpractice?
So if there's medical malpractice, you can hold liable anybody whose conduct fell below the standard of care. So any healthcare professional can potentially be held liable for medical malpractice, including the facility or company where the medical negligence occurred, the facility or company that employs the medical professional that actually committed the negligent act. And many times, more than one party can be held liable. Some of the healthcare professionals that you can hold liable are doctors, surgeons, nurses, hospitals, psychiatric hospitals, and even dentists.
Okay. Now, folks, remember, we're talking with personal injury attorney Mark Underwood on today's Ask the Experts. 844-UNDERWOOD is the number you can reach him at. It's 844-UNDERWOOD. Of course, UnderwoodLawOffice.com is the website you can find them at. Either one is totally fine. They'd love to hear from you. Underwood Law Office is the website online. And, of course, we're talking in regards to medical negligence today with him. Some really fascinating stories in regards to that. We're going to go ahead and take a quick break, and then when we come back, we still have a lot to cover, so we'll bounce out real quick. We'll come back, pick up where we left off with attorney Mark Underwood in regards to medical negligence here on Ask the Experts. Stay tuned, folks. Welcome back to the show, folks. This is Ask the Experts here on Talk Radio 1190. We do this every week, every Saturday, 10 to 12, here on Talk Radio 1190. Joining us right now on the phone line, we got attorney Mark Underwood of Underwood Law Office. And his office is located in McKinney, Texas, for your information. And, of course, if you want to reach out to them, 844-UNDERWOOD is the number. It's 844-UNDERWOOD. And underwoodlawoffice.com is the website. That's underwoodlawoffice.com. We're talking in regards to, injuries as a result of medical negligence, and we're just going to pick up where we left off, Mark. And if somebody is in this situation, what should they do if they believe they were injured by medical negligence?
So the first thing to do is to start gathering your medical records. The second thing to do is to contact a lawyer. Like in the case of the surgical blade left in the gentleman's hand, he tried to live with it and thought he would get better and thought he would get better and thought he would get better. He never did, but he waited so long that he was beyond the statute of limitations. And of course, in that case, we had a picture of the X-ray blown up, and you could very clearly see the surgical blade left in this gentleman's hand. But he waited so long before talking to a lawyer that he blew the statute of limitations and was ultimately unable to recover. So the first thing to do is to take legal action to ensure that you don't exceed the statute of limitations, because those are no excuse deadlines. There's no reason for not getting your case going before the statute of limitations runs.
Yeah, it's such an interesting story, and you got to give the guy credit. 10 years, just be able to deal with that, whatever it might be. It's astonishing, really, and unfortunate that he dealt with it, but in the end, it just didn't turn out to be in his favor. Now, if that's the case, let's talk about compensation. How can they receive that in medical malpractice lawsuit? How does that work, Mark?
So in a medical malpractice case, it depends on the type of injury that you have sustained, how severe that injury is, and how bad or how egregious the negligence in your particular case was. All of those kind of factor in to determining your level of compensation. Compensation can cover future medical bills, current and future wage losses, any sort of disability or long-term care expenses, rehabilitation costs, loss of enjoyment of life, pain and suffering, or loss of consortium, which is companionship. So all of those things are potentially recoverable, but a lot of it depends on how severe those things are and how bad the negligence was.
And that kind of just really plays into where we're going to go next with this. And I'm sure people are curious. Well, we talk about the medical negligence and all that implies and what they should do in that situation. But if they do end up in that, hopefully not, like I've said, but if they do, how much can they be rewarded for medical malpractice damages in Texas? And I'm sure, this is things change state by state, of course, right?
That's right. Different states have different medical negligence laws. Of course, in Texas, you can recover all your economic losses. Those are things like cost of your medical bills and the cost of your lost wages. But when it comes to non-economic losses, like pain and suffering, loss of enjoyment of life, you are capped in the state of Texas. And not all states cap the recoveries for non-economic losses in medical negligence cases. But in Texas, non-economic damages against all doctors and healthcare providers are capped at $250,000 each, and not to exceed $250,000. And for the facility, the hospital where it occurred, they're capped at $500,000 for all the facilities that may happen to be involved. So the maximum recovery for non-economic losses that you can ever get in Texas is going to be $750,000. That'd be $250,000 for the individual providers and $500,000 for the facilities where it occurred.
Is the cap pretty common in states, or is that more just how does that work? Does that seem to be common throughout?
So in the early 2000s, there was a wave of changes to your Seventh Amendment right to a jury trial in civil actions, where they started limiting it, and many states did enact those types of caps. So it's fairly common, but not every state has it.
Yeah, and I know you've worked in different states, so that's why I wanted to ask, of course. Folks, we're talking with Mark Underwood today. Always great to have him on the show. Been with us for a while here on Ask the Experts. It's 844-UNDERWOOD is the number. 844-UNDERWOOD is the phone number you can find him at. And, of course, UnderwoodLawOffice.com is the website. That's UnderwoodLawOffice.com. He's a personal injury attorney here in the Dallas-Fort Worth area. And, Mark, if we've been talking about medical negligence, medical malpractice, what are some of the other requirements of the Texas medical malpractice laws?
So these are some of the most difficult cases to handle.
Why is that?
Well, because they have a lot of specific requirements.
Okay.
And some of the specific requirements that Texas has, which is similar to other states that have enacted changes to their medical negligence laws, are a notice requirement and an expert report requirement and a requirement that you provide an authorization. And let's talk about the notice requirement for a second. So under the Texas Civil Practice and Remedies Code, that's section 74.051, a prospective plaintiff, usually through their attorney, must provide written notice of the claim to each healthcare provider that is to be named in the lawsuit. And that written notice must be provided at least 60 days before suit is filed. And you have to send that by certified mail, return receipt requested. So that's kind of the first step. And in that notice, you are required to provide a HIPAA authorization form that allows the medical providers to have access to your medical records. So you have to provide notice starting out, and you have to provide that authorization form. And then the big requirement is the expert report requirement. It's very similar to what's called a certificate or affidavit of merit, but you have to provide an expert report that lays out basically your claims and how the standard of care is claimed to have been violated. And you must serve that expert report, which can be really extensive and can be occasionally very difficult to get because you don't have all the facts that have occurred. You don't know the doctor's version of the events or the hospital's version of the events. All you know basically is what is in the medical records. And of course, medical records don't always contain all the facts when medical negligence has occurred. So you got to file that. You got to serve that on each defendant at least 120 days, the later of 120 days of filing suit or 60 days from as ordered by the court, or a date in writing that's agreed upon by everybody. But if you don't file that within 120 days of filing suit, your case gets dismissed. So, it's very difficult to find the expert to give an expert report when you don't know all the facts many times.
And I know you were talking about the blade in the gentleman's wrist, and you mentioned that he lasted 10 years. And I wanted to talk real quick and touch base on this one more time. What is the time period, or how long do you have before you can essentially file these and test this in court? What's the time period? How long do they got?
So the statute of limitations is 2 years.
Okay, that's what.
But there's also an exception to the 2 years based upon when you discover the negligence. So the first deadline to really count on is it's 2 years from when it occurred.
Okay.
However, like in the case of the gentleman who had the surgical blade left in his hand, he didn't discover the negligence until that X-ray was taken about 11 years later, actually. So he was. The argument was that he did not discover the negligence until 11 years later. So the statute of limitations should not begin to run until the medical negligence is discovered, until they saw the x-ray with the surgical blade in his hand. But there's what's called a statute of repose. And in most states, including Texas, it's about 10 years in medical negligence cases. And basically what the statute of repose says is even if you discover it later and you file it within 2 years of your discovery, if it's greater than 10 years, it doesn't matter. It's too late even if you don't discover it. So in the gentleman that had the surgical blade left in his hand, since he didn't discover it for 11 years, and there was a 10-year statute of repose, the doctor was not held liable because the statute of repose prevented him from bringing suit, even though he had just recently discovered it.
Gotcha. All right. Well, I'm glad we covered that. I wanted to make sure we got that information out. I wasn't sure if I asked that question earlier, but very interesting topic in itself in regards to medical negligence and the examples that you've seen personally. It's quite astonishing in some of those cases. But we got a couple minutes left on the show, Mark. Why don't we wrap things up? I think the main takeaway that I'm asking you from this is if there's somebody out there that thinks they are dealing with this situation, what should they do?
So, really the first step is to get in to talk to a lawyer, and at the same time, as quickly as possible, start getting your medical records together, because you can't evaluate these cases as a lawyer unless you have the medical records. And sometimes it can take months and months and months to actually get copies of the medical records. So first thing is get into a lawyer. Second thing is with the lawyer or on your own, start getting copies of your medical records, and not just your records, but your X-rays, your CT scans, your MRIs, the actual digital images that they have them on now, so that the case can be evaluated. Because there's just really not much you can do until the lawyer has seen the medical records. But if someone's out there and they think they've been through medical negligence and they want to talk to us, they should feel free to give us a call at 844-UNDERWOOD. We'd be happy to talk to them. We would get a copy of their medical records, have some doctors that we are friends with take a look at it. If they think it's a case worth pursuing, we would find an expert that can give us a certificate of merit or tell us the case is not worth pursuing, and we can look at whether or not we can obtain compensation for their injuries.
All right. Any closing remarks for our listeners out there?
Nope. Just give us a call at 844-UNDERWOOD or check us out on the web at underwoodlawoffice.com. We're happy to talk to you.
Perfect. Well, I'll tell you what. Like you said, 844-UNDERWOOD is the number you can find them at. Underwoodlawoffice.com is the website you can find them at. And, stay tuned. Always pay attention to it because we always have Mark on here about once a month, and it's always great to have him on. Again, Mark, great to have you back on Ask the Experts. We always look forward to talking to you, and we'll do it again here very soon. How about that?
That'd be great, Matt. Stay cool in the meantime.
Yeah, I'll try to. You do the same, all right? Another edition of Ask the Experts in the books with Mark Underwood. Always a pleasure having him on the show. It's always a joy. And, we got one more before we wrap things up today, so stay tuned. This is Ask the Experts here on Talk Radio 1190. We'll be right back in a couple minutes. We just got a quick break, and we'll be back on Talk Radio 1190.